Good afternoon, everyone. My name is Alexis Alvarez Bartholomew, and I'm the Director of Statewide Training at Florida Legal Services. Thank you so much for joining us on this Monday for this exciting topic on property tax in Florida. So just to give you a little background about this training, I know we all in legal aid and in public service experience some tax issues and some property issues, and sometimes we don't know what to do. We don't know who to ask. And that got me to think, what can we do? What can we train on this? Who can I bother to give us a training and talk about this important subject? So I'm excited to bring this to you because I know how much it's needed in the community. And I know for some of you, the topic may be, foreign to your practice, but ancillary to your practice or touching some things that you do. Either way, I'm certain by the end of this, you will get something valuable in order to aid you in your practice and aid you in your representation of our community and our clients. So before I go into introductions and we move into the content, I always like to go through some housekeeping announcements. First and foremost, this is being recorded. A copy will be sent to all of you who are here and all of you who registered. So don't worry if you have to hop off, you have to go do something else for work. The recording will continue, and at the end, you will receive a copy of the recording so you can look back and review everything that you need. Secondly, this is approved for CLE credit through the Florida Bar. I will announce that CLE code at the end after the content. If you miss it, don't worry. I'll also make sure that CLE code is included in that email with the recording that you will receive. So don't worry, either which way, you will get that CLE credit. Worst comes to worst, I'm going to drop my email into the chat. If you don't see that email in your inbox or you need anything else, you can always reach out to me directly. You know I am always here to help. Third piece of housekeeping announcements, closed captions have been enabled for anybody that does need that little extra accessibility to follow along today. If you're struggling to onboard those or need anything, just DM me separately, or again, I'm going to put my email into the chat and I will do everything I can to connect you. And the final piece of housekeeping announcements are questions and answers. Please feel free to drop your questions into the chat or the Q&A. Throughout the presentation, I will be aggregating and monitoring those questions. And at the end, if time permits, our speaker has agreed to answer what he can with that time. So, I always say this for those of you who have been to my trainings before. It's a virtual vortex. It may feel wonky and disconnected, but we're a learning community here. So don't be shy. Drop your questions in. We do want to hear from you. So moving on into the speaker that we have here today. I give a warm welcome to Daniel Wolfe, who is partner at Rennert, Vogel, Mandler, and Rodriguez. He concentrates his practice on ad valorem property taxation, representing real property owners before the Value Adjustment Board in Florida courts and representing clients in commercial real estate transactions. Before joining Rennert, Vogel, Mandler, and Rodriguez, Mr. Wolfe's practice focused on handling complex real estate transactions, including acquisition and disposition, development, leasing, construction, and permanent loans and loan refinancing. Mr. Wolfe is a graduate of, you guessed it, how did I get him to agree to speak with us? The University of Miami School of Law, receiving his JD magna cum laude in 2015. So fun fact for you all, I've actually also known Dan, as I call him, since I think we were in elementary school. So I am beyond excited to feature him as a speaker here today, not only because I know the great work that he does, but I've known him for a long time, and he is a magnificent lawyer and a wonderful person. And thank you so much for being here, Dan. We are very excited to learn from you.
Well, Alexis, thank you very much for the kind introduction. It's true, we've known each other since I think 5th grade. When I was the new kid at your elementary school, you befriended me right away. So I have to thank you again for that. And I also have to thank you for saying that property tax is exciting because, I'm sure for most of you viewing at home, that just seeing the word tax is probably scary enough. And it certainly was for me before I got into this field. But I think you're going to find, or at least I hope that you're going to find at least portions of this presentation exciting, and if not exciting, at least interesting and informative. So like Alexis mentioned, I concentrate my practice on ad valorem tax, which is essentially property tax appeals. Most of what I do is commercial property tax appeal work, but I do a handful of residential properties every year as well. I also handle exemptions, homestead exemptions, most recently live local exemptions for workforce housing. And so, anything property tax related, I've had my hands on at some point, just about. So again, today we'll be discussing property tax in Florida. I've divided this presentation into three main topics. The first one is going to be just sort of an overview of property tax in Florida. We're going to look at some of the key terms to be aware of. Who are the key players? You have the property appraiser's office, you've got the tax collector. Also some key dates and deadlines to be aware of in a typical property tax year. Following that, we'll discuss the property tax appeal process, which is, again, what I do basically every day. We'll talk about everything from filing a petition to appeal your taxes to the process of what it looks like once your case has been set for hearing. There's an evidence exchange process that has deadlines and rules to be aware of. And then we'll discuss what happens at hearing. Who are the parties that are going to be at the hearing? What does that process look like? And what are some strategies and tips to be successful at hearing, as well as what are some pitfalls to avoid as well. And following that discussion, we will lastly talk about the homestead exemption. And so, in deciding what to talk about for this presentation, the first two topics were easy. It was coming up with a third topic. And I really think homestead makes the most sense because it just in terms of Florida legal aid and what you would typically come across in terms of the clients or the people that you're dealing with. We get cold calls every single week from people wanting to discuss homestead, whether it's applying for the homestead exemption, and unfortunately, what happens when you lose your homestead exemption, which can be very devastating. So we'll talk about homestead just to give you a quick 5-second preview on what homestead is. It's essentially if you own property, if you own your home, condo unit, a townhouse, whatever it may be. If you own a home in Florida and that's your primary residence, you should apply for homestead because it's a tax savings and it caps what your value can increase to year after year. So homestead's very important. We'll go more into detail on that when we get there. So those are the three main topics. We'll start with an overview of property tax in Florida. All right, so what is taxable? So basically all real property and tangible personal property in Florida is taxable. Now, real property is pretty much everything you would envision. Your home, an office building, a retail center, vacant land. That's all real property. That's pretty obvious. Tangible personal property is, you can think of it as like furniture, fixtures, and equipment that are utilized in a business for commercial purposes. So that would be, for example, let's say you're running a hotel. It would be like the beds, the dressers. If it has a fitness center, it'd be all the gym equipment. If it's a pool, it'd have to be like the pool chairs. All of that would be tangible personal property, which is, again, that's also taxable. But again, that's only in the commercial side of things. For residential, you don't have to worry about TPP. So again, the default position is everything is taxable unless it's immune or exempt. Immune property is property that's non-taxable on its face, meaning it's automatically non-taxable. You don't have to apply for anything or fall under some sort of a specific exemption. Just right from the get-go, it's non-taxable. Examples of that are like property owned by the United States government, property owned by the state of Florida, property owned by the counties. Exempt property, on the other hand, is property that would be taxable, but the property qualifies for a specific exemption, whether it may be affordable housing, charitable exemptions, religious exemptions for temples or churches, and then most commonly, the one we're going to talk about, homestead exemption. And exempt property, another difference from exempt property versus immune property is just the whole thing is non-taxable. Exempt property can either be wholly non-taxable or partially non-taxable, meaning so like if you have homestead, you're still paying taxes, you're just paying less taxes than you otherwise would if it wasn't exempt. So the next big question is, how do you calculate your property taxes? It's really composed of two main variables. You've got the appraised value, which is determined by the property appraiser's office. And then you have the millage rate, which is just a set percentage. And you multiply those two factors and you get property taxes. So, and I know, by the way, I know we're all lawyers, we don't like math, so I'm going to try to keep it as simple when it comes to the math as possible, but so bear with me on that. So I'll give you a simple example. say you have an appraised value of $1 million, your house is $1 million, you have a millage rate of 2%, you're looking at property taxes of roughly 20,000. So who are the key players? You've got really three main key players. You've got the property appraiser's office, who's in charge of assessing your property according to its just value. And that term just value we'll talk about on the next slide because it's important. So that's the property or the party that determines your value. It's the party that you go against when you're trying to argue for a reduction in your taxes. You're arguing against the property appraiser. The tax collector, on the other hand, is the party that's in charge of billing and collecting your taxes. So when you receive your tax bill in November, that's going to be from the tax collector's office. And when you pay your taxes, hopefully in November, and you get a benefit by paying early, the deadline would be in March, you're going to be paying them to the tax collector. Now, clients ask me all the time or confuse all the time the property appraiser and the tax collector. I can't tell you how many times clients will reach out to me saying they're trying to argue for a reduction in their taxes or they're not getting the exemption. It's not showing properly on their on the website. And I come to find out that they're not actually contacting the property appraiser, they're contacting the tax collector. So right away I have to tell them you're barking up the wrong tree. But again, they're related entities. They work together a lot. In fact, they're in the same building, at least in Miami-Dade County, but they are two different entities. The third entity is that you should be aware of, or the third key player, is the Value Adjustment Board. They oversee and administer the tax appeal process. That's the neutral third party that when you appeal your taxes, you're appealing them at the Value Adjustment Board in front of a special magistrate employed by the Value Adjustment Board. So again, you file your petition with the VAB, you go to the VAB to appeal your taxes, and it's a representative from the VAB that will ultimately give you your result. And it's an administrative forum, essentially, to appeal your taxes. Okay, so the term just value. So remember, the property appraiser assesses property according to just value. It's a unique term in Florida. You won't find it in any appraisal treatise or any books on appraisal. It's specific to Florida. And the Florida statutes set forth 8 factors that the property appraiser's office is supposed to take into account in determining just value of property for purposes of assessing it. The first one is the present cash value. You can think of that as simply the price that a willing buyer would be willing to pay from a willing seller, an open market transaction, arm's length. This is not you getting your property from your father and paying a small amount or your next door neighbor knocking on your front door and asking to buy your property. That's not what present cash value is. Again, it's an open market, arm's length transaction from a willing buyer to a willing seller. The highest and best use factor is one that comes up a lot in what I do, certainly with commercial. It's essentially the highest and best use for what that property is. And it's an important distinction. It is not necessarily the current use for the property. Best example I can give, let's say it's a property, it's like a dilapidated, 1950s year built retail property, right? But the land is zoned to build a 50-story office building, let's say. The property appraiser isn't confined by having to appraise it as this old crummy retail property. They're able to take into account the fact that even though you're not building it up to its potential, it's still a value. It'd still be somebody would be willing to come and purchase that to build, a 50-story office building. So a lot of, going back to the appeals process, we're always arguing what is highest and best use. It's not always clear cut like that example. Location is the next factor. That one's obvious. Location, location, location. Quantity or size is the next factor, which is also pretty obvious, but it takes into account both the size of the improvements, but also the size of the lot that the improvements are on as well. The next factor is the cost, which is the cost to reconstruct or replace whatever the current improvements are. Following that is the condition of the property, which again, that corresponds to not only the improvements, which is pretty obvious, but also the land. Maybe the land is dealing with environmental issues. It needs remediation. Maybe it's partially wetlands that can't be built on. So all of that would obviously be taken into account. Following that is the income potential of the property. That only applies to commercial. So when we're talking residential properties or your house or condo unit, that factor doesn't come into play at all. And then lastly, we have the eighth factor. And this one, to be honest, I could do an entire presentation on this eighth factor because it's very controversial. Counties don't always look at this the same way. So it's the net proceeds of sale after deduction of usual fees and costs. I'm going to just give you very simplistic since we don't have a ton of time. What essentially that is, let's assume that you purchase your property for $1 million, right? The property appraiser uh, what this eighth factor says essentially is that the property appraiser's office needs to deduct from that purchase price the usual fees and costs of the sale. So what would those be? Well, you can think of those as like broker's fees, title fees, attorney's fees in connection with the sale. Maybe there was a survey that had to be done. All the things that if you've ever bought property before and you get a settlement statement or a closing statement, it lists all these line items of costs. Those are all things that the property appraiser should be deducting from your purchase price to come up with an assessment. So going back to the example, you purchase your property for $1 million, the property appraiser's office is supposed to deduct the usual fees and costs of sale. Now, what counties have done is instead of having to look at every single sale and decide, okay, what are the fees and costs for each individual sale that takes place in our county, what they've decided to do instead is use a uniform percentage, a 15% in most counties. Some counties use a different percentage, but most counties in Florida use a 15% deduction here. So going back to that $1 million example, you would have a purchase price of 1 million, and then you would deduct 15% of that. So roughly $150,000 to come up with a value of 850,000 for the assessment. Again, that's assuming the property appraiser is basing the assessment solely on your sale price, which more often than not they do when it's a arm's length, no issues with the sale, and the sale took place a year before the assessment date. All right, so that's the just value. The next component is the millage rate. Remember, going back to my very simple equation to get to your taxes, it's appraised value times millage rate equals taxes. So the millage rate I also like to refer to as the tax rate, and it's generally made up of 4 separate millages or 4 separate categories. You have the state, the county, the municipality, and the school board, which all, again, they all have their each individual millages, and when you add them all up, it equals your overall millage or tax rate. On average in Florida, it's around 2%. Now, it really depends though. For example, Collier County or Monroe County, the Florida Keys, the millage rate is as low as like around 1%. So it can be a lot lower depending on where you are, but on average, it's about 2%. And millage rates, we don't fight those. As a property tax appeal professional, we don't worry about the millage rate. That's not something you can even fight at the Value Adjustment Board. They have no jurisdiction over that. You just kind of have to leave the millage rate for what it is. All right, this next topic is a little bit confusing, but I had to include it because I get asked this honestly probably weekly, and it's a little bit confusing. So I'm going to do the best I can here. If you get lost, it's not on you, it's on me. All right, so there are 2 values when you look up your property on the property appraiser website or when you get your tax bill. You're going to see a market value, which sometimes is called the just value, and you have the assessed value, which is sometimes called the 10% capped or capped value, but we'll just refer to them as market and assessed. The market value is whatever the property appraiser deems your property is worth on January 1st of the tax year in question. So it's not capped, meaning it doesn't matter what your property was worth last year or the year before. It's essentially whatever they think your property is worth on January 1st. So it could, in theory, go up 100% from last year. The assessed value, on the other hand, is capped, and meaning it can't increase by more than 10% from the previous year, regardless of if the market value goes up by more. Maybe the market value goes up by 20 or 30%, like we've certainly seen in certain areas in Miami-Dade. But again, if that happens, the assessed value can't go up by more than 10. So oftentimes what you're going to see is the market value is going to be higher than the assessed. The assessed value can never be higher than market, though. They can either be the same or the market can be higher than the assessed. And what's not on this on this PowerPoint slide here, which I probably should have included, is that assessed value does reset to market anytime there is a transfer of the property. So when you buy your property or you buy a new property or sell it, then next year that assessed value automatically resets to market. So, I mean, if you think about it, it's a big reason why you can never rely on the taxes that the previous owner was paying in terms of predicting what your taxes are going to be if you purchase the property, because those taxes are those values are going to reset. Assess will reset the market. Both values matter, and this is probably the most important thing. If you're going to remember one thing from the slide, it's that both values matter in calculating your property taxes. How they get calculated is a little bit more confusing, and this is where I might lose some of you guys. But just remember, going back to the millage rate, it's comprised of four separate millages, right? State, county, municipality, and school board. Those first three, the state, municipality, and county categories, those millages apply to the lower assessed value. The school board, on the other hand, their value or their millage applies to the higher market. You ask, well, why in the world is that? It's because when they first introduced this concept of the 10% cap, like 10, 15 years ago, the school board decided or lobbied very hardly to make sure that their values were not capped. They wanted to get the most tax dollars possible, and they were successful in doing so. So they get the benefit of getting their portion of the taxes applied to the higher market value. And if you're looking at it on a percentage basis, so those three categories, state, county, municipality, that accounts for roughly 70% of the overall millage. The school board accounts for roughly 30%. So again, I don't expect, maybe only a quarter of you are able to follow along with me at this point. I totally understand. Remember, just remember both values do matter. All right, so here's a typical, and I'm using 2024 as a base here, as an example. This is like a typical calendar year for property tax purposes. January 1st, we sort of talked about this. This is the date of valuation. Again, it's a snapshot of your property on that date. It's how the property appraiser assesses your property. March 1st, 24 is the deadline to apply for property tax exemptions, most notably Homestead, but it's all the other ones, affordable, charitable, religious, that's all on the same deadline of March 1st. July and August are typically when the new assessments are first available online. However, this year in Miami-Dade County, they're already available for some residential areas, and we're only in June. So really that should say June, July, August. More typically it's July, August. August 2024 are when the trim notices are mailed to the public. Your trim notice is essentially, it's a notice from the property appraiser's office listing what your preliminary assessment is going to be. And I say preliminary because it could change. It oftentimes does not, and even if it does change, it only changes very minorly, but it can. So I have to say it's only just a preliminary value, but it at least gives you an idea of what your taxes are going to look like ultimately when you get your tax bill later on in the year. September 2024 is the deadline to file your tax appeal petition if you want to contest your taxes at the Value Adjustment Board. And it really varies depending on what county you're in when the deadline actually is. They're all in September. I think Miami-Dade and Broward were like September 17th and 18th this past year. But some counties are that first week of September. So you do need to be aware of your deadline in whatever county your property's in. October 2024 are when the first hearings are set. And we look at that as the commencement of the tax appeal season. November 2024 are when the tax bills, the final tax bills, are mailed to the public. And, these, again, this dating back to a previous slide, the tax bills are mailed from the tax collector. The trim notices, which we talked about in August, those are mailed from the property appraiser's office. So that's a key distinction to be aware of there. March 31st, 2025 is the deadline to pay your 2024 property taxes before they are deemed delinquent. And then finally, May of 25 is when the end of the tax appeal season occurs. It's the last month where hearings are being set. One thing that's not on here that needs to be stated, though, is if you pay your taxes early, so again, the deadline's March 31st, but if you pay your taxes in November of 24, you get a 4% early payment discount. If you pay in December, you get a 3% early payment discount. If you pay in January, a 2% discount. And if you pay in February, a 1% discount. So I always say, if you have the cash on hand and you're able to pay early, we always encourage our clients to do so. All right, so I'm gonna need a much needed water break. All right, so now we're gonna talk about the property tax appeal process, which is what I do. So the first step of the process is to file the petition. As I mentioned, all the deadlines for the various counties are in September, but they do vary from one county to the next. The cost for filing a petition is $15 per property. What it really should say is property folio. Every property gets its own individual tax folio. And sometimes, like for example, if it's a big retail center or a hotel or something, sometimes a property is composed of more than one folio. So it is technically $15 per folio. So if it's a property of, let's say, 3 folios, you'd be looking at $45 total to file a petition. The petition, it's a simple one-page document that gets filed with the VAB. This is not your opportunity to argue your case or present any kind of supporting documents. It's just strictly an administrative one-page document, basically saying, I want to appeal my taxes and please give me a hearing date. That's all it is. Okay, so what happens if you miss the filing deadline? Well, the good news is you can file late, but you need to provide an excuse for why you filed late, why you missed the deadline. It's called extenuating circumstances is what they refer to as the excuses. And it typically, it's so you file a late petition and you attach like a one-page document evidencing what your excuse is. Maybe you were traveling outside the country during the filing deadline. Maybe you didn't receive the trim notice, so it was the property appraiser's fault. They didn't send you the taxes on time. Maybe you were dealing with health issues, death in the family, something along those lines. Those are all examples of things that have worked in the past, but you have to provide a legitimate excuse in order to file late. Some counties are stricter than others in accepting late petitions, and I say some, most counties, including Miami-Dade County, where I do the bulk of my work, require the taxpayer to actually attend a hearing, a separate hearing to prove the extenuating circumstances. So it's kind of a pain. It's a little bit of an administrative headache because, you have to attend one hearing just to get the right to appeal your taxes at another hearing set on some future date. An important factor in filing late, the longer you wait to file, the less of a chance you have of getting your late petition granted. Kind of makes sense. If you miss the deadline by a few days or a week or a couple weeks, it'll be looked at more fondly than say you're trying to file late in January, February. Okay, so now your case has been set for hearing. So you're you're given no less than 25 days notice of your case being set for hearing. The default position is you receive a notice in the mail, but you can actually elect on the petition if you want to receive notice via email. But in any event, so you're given no less than 25 days notice. You must exchange whatever evidence you intend to rely on at the hearing no later than 15 days before the hearing date. You have to exchange that with the property appraiser's office. So, examples of evidence would be maybe you're relying on comparable sales, an appraisal, maybe photographs of the inside of your home or your property showing that it's in bad shape, whatever it may be. All of it, point being, anything you plan on presenting at the hearing needs to be exchanged no less than 15 days. Assuming you do that, assuming you meet your evidence deadline, the property appraiser then must submit their evidence to you no less than 7 days before the hearing date. So it's a little bit of a disadvantage for the taxpayer, which you might be able to gather because we have to submit our evidence first. And the property appraiser has the benefit of seeing our evidence before they have to submit their evidence. So you can imagine it gives them a little bit of an advantage there. The good news is there is a process in place for us to then be able to submit rebuttal evidence. So anything, maybe the property appraiser is relying on a sale that we know isn't a good sale. Maybe we have information showing it was a 1031 exchange, or maybe it was, part of an assemblage. It was a buyer that was just, asking his next door neighbor to buy the lot. It wasn't a true arm's length marketed transaction. You can provide all that documentary evidence as rebuttal, but you must do so no less than 2 days prior to the hearing date, which this is sort of a general rule. The rules on rebuttal can vary depending on what county you're in, but this tends to be the general rule for most counties. So it's a little difficult though, because the property appraiser oftentimes waits until the last possible day before they submit their evidence, and then you must submit your rebuttal no less than 2 days before the hearing date, which really only gives you 5 days to kind of review the property appraiser's evidence and submit rebuttal. It's a little bit tough, but you have to do what you can. All right, so now we have the actual hearing. So in Florida, now most counties allow for telephonic hearings. And this was a development that occurred because of COVID. And what happened was, so COVID was a couple of years where, they still blame COVID for wanting to do telephonic hearings. And what happened was everybody liked telephonic hearings more than having to show up in person, whether that be the taxpayers, the property appraiser's office, or the magistrates themselves. And so now almost every county, with the exception of like Sarasota, maybe one other, allow for telephonic hearings. They're presided over by a special magistrate who is not a judge and does not even necessarily need to be a lawyer, except for certain types of hearings, legal hearings that implicate legal issues, like exemptions, for example. But if you're just arguing for a reduction based on value, they got the value wrong. That is presided over a magistrate that is not a judge, not a lawyer, doesn't necessarily need to be a lawyer, could be, but they do need to be a licensed appraiser. So that's who sort of is the quote unquote judge who's deciding your case. Also present at the hearing is a representative from the property appraiser's office, and they're there to defend the assessment. So if it's a big case, sometimes it's multiple representatives. I've dealt with as many as 5 before on big cases, but it's typically only one. And the way it works, the typical process is the property appraiser presents his or her case first. Then you get the opportunity to present your case after the property appraiser, your argument. The PA then has the opportunity to present rebuttal, and then you have the opportunity to present rebuttal. So whereas the evidence exchange process favored the property appraiser's office, the actual hearing process favors us, favors the taxpayer, because we get the last word. We get to see what the property appraiser actually argues before we have to argue. It's always great having the last word. Oftentimes, these magistrates see as many as 50 cases or more even in a single day. So the last thing, it's nice being your voice, being the last thing they're going to hear on a specific case. All right, so rarely, if ever, does the magistrate actually rule at the hearing, although you can usually get a pretty good idea how they're going to rule. You may not know the exact number, but you'll usually be able to get an idea if they're going to give you something. And although some will just straight up tell you if they really feel like doing so, I'd say it's very rare, but they once in a while they will tell you. More often though, you'll get the result within a week or as long as a month following the hearing date. That depends on what county you're in, who the magistrate is. Some magistrates are faster than others, but also at what point in the tax appeal season your case is set for hearing. If it's set earlier in the tax appeal season, you can expect your result quicker. But as the season drags on and these magistrates fall a little bit behind, which is inevitable, it typically takes a little longer. So if your case is set in October, very fast. If it's set in February, you might have to wait a little while. Following receipt of the hearing results, I say some, most counties allow either you or the PA representative to write for reconsideration. It's essentially an informal appeal of the result. It is not an opportunity to relitigate your case, though. You basically have to be pinpointing one or a couple things that went wrong with the hearing, or that, in your opinion, were mistakes or errors that the magistrate made in deciding your case. And you have to really focus on that. Again, if you try to relitigate your case in this reconsideration, it'll just get denied right off the bat. You're also unable to ever introduce any new evidence or any new arguments that were not previously made at the hearing. If either party, meaning either you, the taxpayer, or the property appraiser's office, is still unhappy with the result following reconsideration, both parties have the ability to file a lawsuit in circuit court to contest the result. Now, we do that. We do file lawsuits on a handful of cases every year. Obviously, they need to be large cases. They have to, there has to be a lot of money involved because, as we all know, litigation is very costly and time intensive. And it also, they have to be cases that we feel very strongly about. Um, Same thing with the property appraiser. The property appraiser files a handful of lawsuits as well, and it's typically the same understanding on their part. They're typically large cases where they feel very strongly about. The only difference is they'll oftentimes file even on small cases if there's a key legal issue they feel very strongly about because they don't want to be creating bad precedent um, through this VAT process. If it's a legal issue they feel strongly about, they more often than not will file a lawsuit. All right, so here are some successful strategies and pitfalls to be aware of. And I'm gearing this towards residential properties. I'm not, we're not going to focus on commercial here. That's a totally different analysis. So for commercial properties, the number one thing to, or for residential, the number one thing to focus on are comparable sales. And what are comparable sales? Comparable sales are anything or any homes that are similar from the standpoint of age of the property, location, size of the home, size of the lot, what kind of extra features, pools, tennis courts, things like that. What neighborhood you're in, as well, is obviously very important. If you're in a gated neighborhood versus not gated, even if they're right next to each other, could be important. Um, so and again, the timeline of these sales is important. It should be, to be considered timely would typically be sales that occurred within a year of January 1st of whatever tax year. And there could be sales that occurred after January 1st, but you don't want to go too far past, call it March, first quarter of that tax year. Otherwise, it's too dated or too recent, and it should be looked at for the following tax year. So it's very important to distinguish comparable sales from comparable assessments. Now, I've seen, taxpayers argue their taxes all the time, pro se, on their own. And almost always, inevitably, they're arguing that their neighbor's assessment is much lower than theirs, or that their neighbor's paying way lower taxes than theirs. Magistrates don't care. They don't care what your neighbor's paying in taxes. That's a surefire way to lose. You need to come in with comparable sales. Because remember, when we went back, looking back to how you define just value, you'll notice in those 8 criteria, nowhere on there was comparable assessments. They don't care what your neighbor's assessing. It could be the property appraiser is incorrectly assessing that other property that you're bringing in. What they do care, though, is the actual sales, because those are market transactions. Those are, in theory, are supposed to reflect actual market value, because it's a third-party buyer buying from a third-party seller. In theory, that should be the best indication of what true value is. So one other thing, and I included this last note on this slide just because I get so many calls on this. If you recently purchased your home and it's being assessed at 85% or less of the purchase price, you're wasting your time appealing it. You're going to lose instantly. The magistrate's going to see the price and just say, we're done. It doesn't matter, again, that your buyer or your seller was being assessed way lower. And more often than not, the seller probably had Homestead, so that was capping the taxes anyway. The magistrate doesn't care, though. As long as as long as they're assessing it at 85% or less of the purchase price, that's really all that matters. And so unfortunately, more often, I get calls all the time from prospective clients. Oh, my taxes jumped 100 or 50%. This is crazy. Unfortunately, there's nothing you can do in that case. All right, so here's some other considerations. So I kind of alluded to this already. You don't need to be a lawyer or an appraiser to appeal your own taxes. You can appeal your own taxes of your home if you want to. And some, like Miami-Dade County, for example, some counties do have a comparable sales tool right on their website to allow you to search for comparable sales to try to build a case. The Miami-Dade actually is a very good tool. It's probably one of the best ones, but a lot of them are difficult to deal with and work with. And like I mentioned on the previous slide, most pro se taxpayers have difficulty winning their appeals because they don't understand the way the game is played. There's a lot of knowledge and experience involved in this. So the advantages to hiring a tax appeal professional is we know what the magistrates are looking for. We know how to rebut the property appraiser's data or evidence. We also have access to appraisal software and data that the typical taxpayer is not going to have. We subscribe to CoStar and LoopNet and other appraisal software. So we have a lot of information. We might be able to know certain information that's not public on whether a sale is actually a true qualified sale or not. We subscribe to MLS. So, we have a lot of weapons at our disposal to fight your taxes. The third thing is can't be diminished at all. It's very important that we have relationships with the property appraiser's office and the magistrates. We go in front of the same magistrates over and over again every year for multiple years. A lot of times, there's very little turnover generally with these magistrates. So we develop relationships with them over time. Same thing can be said with a property appraiser's office. We know all the folks over there, at least in the counties where we practice a lot in. For me, it's Miami-Dade and Broward. And the reason, on top of the fact it's just, we have a rapport, is that's helpful to try and settle cases. So we never even have to go to hearing to begin with. We see what the assessment is. We can go straight to the property appraiser and argue that it should be reduced. Almost all tax appeal professionals work on a contingency fee basis, meaning the taxpayer owes nothing if the tax appeal is unsuccessful. Otherwise, the fee is a percentage of whatever savings are obtained for the first year. And typical contingency fees range from 30 to 40%, I'd say is considered market. All right, so now we're about to start the last topic, which is Homestead. And before we go to the next slide, just, Homestead again, it's if you own property in Florida and you reside there. If you own a home, if you own a townhouse, if you own a condo unit, you should be applying for Homestead right away. You should be taking advantage of it sooner rather than later. So what are the benefits? So right off the bat, you get up to a $50,000 deduction in your assessed value. Now that is not a $50,000 deduction in your taxes. I wish that would be amazing. It's a $50,000 deduction in the value. So that corresponds to a little less than $1,000 in tax savings typically. Again, that depends on the millage rate, but you can look at it about $1,000 benefit. The bigger benefit of Homestead is actually the fact that it caps your increases to no more than 3% from the prior year. So remember, if you don't have Homestead at all, if it's a commercial property or it's a property that doesn't have Homestead, you still have that 10% cap that we talked about previously. But with Homestead, it's a 3% cap. And not only that, you don't even have to worry about what your market value is, because in Homestead law, or in the Homestead world, the school board doesn't get the benefit of charging on the higher market value. They charge also on the assessed value. So the market value becomes completely irrelevant for purposes of calculating your taxes. You only care about your assessed value, which again is capped at 3% increases year over year. All right, so what are the eligibility criteria for getting Homestead? First, you must own a residence in Florida as of January 1st of the tax year in question. I highlight own. We're going to have to talk about ownership more in a bit. The second criteria is you must, in good faith, make the property your permanent residence as of January 1st. Highlight permanent residence. As you can guess, we're going to have to talk more about that as well. And then the last requirement is you must submit a Homestead application by March 1st. You do not get Homestead as of right. You have to proactively apply for it. And you also, let's say you could have qualified for Homestead in tax year 2024, but you forget to apply, you apply then in 2025, you do not get the benefit of getting, the tax savings from 24. You've lost out on those entirely. There's no retroactive application of Homestead. So you'd be starting in tax year 2025 getting the benefit. All right, so the ownership requirement. So what does that entail? So you must have a deed recorded in the county where your property is located, and that deed should be in your own name, showing you as the grantee of the property. Now, there are some exceptions. The first one, which is the most common, is if your property is owned in a trust. So the trust needs to, one, you have to be the beneficiary of the trust, and per the terms of the trust, you must be entitled to a present possessory right to occupy the property. So some counties are way more strict with this, like this exception of homestead law than others. Like, for example, Broward and Palm Beach are not as strict. You essentially just have to sign a form essentially saying that you are the beneficiary of a certain trust entitled to a present possessory right. You don't even have to give the property appraiser your trust at all. They don't even need to see it. You just have to sign this form attesting to those facts. Then you compare that with like Miami-Dade County, where they actually require you to give the trust. And not only that, they scrutinize that trust up and down. They not only does it have to give you a present possessory right, but they want to see language in there explicitly giving you the right to claim that property as your homestead, or else they'll reject it. So it's important to keep this in mind. This is the thing I deal with almost more than any other in property tax, because we have so many new buyers coming in from out of state that have these out of state trusts that weren't designed to comply with our homestead law. And so they won't have this necessary magic language in there. And it requires them to having to amend their trusts, and then it becomes a whole timing issue. So this is one, a big sticking point in homestead tax law I deal with, again, almost every week. All right, so that's the biggest exception. The next one is if you are leasing the property subject to a 99-year lease. So typically, if you're a tenant, you're renting a property, you don't have the right to claim homestead. The exception, again, though, is if your lease is 99 years, because at that point, you're basically like an owner, or at least that's how the law views you. The third example is if you are a vendee in possession. I should say third exception, no example. Third exception. What that is, it's pretty limited. It's if you're occupying the property as of January 1st. So you're in possession of it, but you don't technically own the property yet. You are under contract to buy the property, and that contract is recorded in the public records. So there's a full record of it. You're going to be the owner and you are possessing the property. That is a limited exception where you can still claim homestead, even though you're not technically the owner on that date. Where this actually comes into play the most is when you are already a tenant, right? You're renting the property to begin with, and you decide to buy the property from your landlord. So that's the example, because you already have a contract in place, or you enter into a contract. You don't technically own as of January 1st, but you're already possessing the property. As long as you record that contract, you can claim homestead. All right, the last point is so important here. Again, get a lot of calls on this. LLCs and corporations cannot have homestead. And where this can become a big problem is if you get homestead in your own name and then decide at some point to transfer the property into an LLC. Maybe, your lawyer or somebody told you it's good to do that for liability purposes or whatever. Point being, you can't do it. If you do that, you're going to lose your homestead. Meaning, you lose whatever benefit you accrued, whatever differential between assessed and market, that all goes away if you transfer the property into an LLC or a corporation. All right, so remember the other requirement was the permanent residence requirement, defined as that place where a person has his or her true, fixed, and permanent home and principal establishment to which, whenever absent, they have the intention of returning. And the key word there is intention, which we'll talk about more in another slide. You can only have one permanent residence at a time. So, you can't claim, let's say you live in New York, you have a vacation home in Florida, you cannot claim that vacation home as your homestead. It also does not require continuous physical presence, though, without interruption. So obviously, if you have a vacation home somewhere else that you go to for a portion of the year, or you travel a lot for work, or whatever it may be, obviously you can keep your homestead under those circumstances. This last one, I included this last note because I think it may come up for you guys in what you do with Florida Legal Aid. Immigrants on temporary visas cannot claim homestead. They have to have permanent visas in order to claim homestead. It doesn't matter how long they've been here, or if they intend to be here, if they're in the process of getting their permanent visa, doesn't matter. If they have a temporary visa as of January 1st, or I'm sorry, if they don't have a permanent visa, really is what I should say, then they cannot claim homestead. All right, so the permanent residence requirement, remember, it's intention. It's one of those things that you have to prove through factual circumstances. And so there's like several factors that the property appraiser is supposed to look at to determine whether or not you are truly maintaining the property as your permanent residence. And these factors are actually all found in the statute. So they are important. It's not just some regulations the property appraiser's office makes up. You will find these in the Florida statutes. The first one is a formal declaration of domicile recorded in the public records. That one doesn't come into play very often. The next one makes sense if you think about it. The evidence of the location where your children are registered for school. So if your children are registered for school down the street, or at least within the same city of where you're claiming homestead, it's that shows some intent that you are in fact maintaining a permanent residency at that property if it's right down the street from where your kids are going to school. Your place of employment, same idea. If you're working at least within the same city, it doesn't have to be the same city. Let me back up. Obviously, it's more about just proving you're actually here, right? As opposed to maybe Orlando or another state if you're trying to claim it in Miami, for example. The next one is your previous permanent residency in another state or country. That's really so that the property appraiser can see or check if you're really maintaining another residency somewhere else. The next three entries I've bolded and underlined because they're the most important. They're also ones that you have to proactively provide when you're applying for homestead. So the first one is your voter's registration, and it has to be updated to show your homestead address. Same thing with your driver's license. It has to be updated to show your driver's or your homestead address. And then finally, your car registration, same thing. So those three things, I say almost every county requires that you provide those three things, copies of them, in along with your application. The next one is your federal income tax returns. Again, that's important for two reasons. One, it should show your current homestead address. But two, a lot of times property appraisers want to see, I think it's Schedule E of your federal income tax return, which is whether or not you're receiving rental income as part of your gross income. And you have to list on that schedule all your rental properties, the address and how much you're getting in rent. So this is sort of a red flag because they may not be aware of. Like, let's say you're claiming a property as homestead, but you're actually renting it out. You're not really living there. The property appraiser's office can see that on your federal income tax return, assuming you're including that rental income on the return. So that's why they ask for that sometimes, although not always. Bank statements and checking account, again, to show that the address on there is your homestead address. And then finally, proof of payment of utilities at the homestead address. That one makes total sense. They want to see that you're actually living there, paying utilities. That one's self-explanatory. All right, so how do you apply for homestead? Most counties now allow you to apply for homestead online through the property appraiser website for that county. And it's usually right on the front, like the first page, the home page of the property appraiser website, and in most counties, because they're trying to make it as easy for the taxpayers as possible. Otherwise, if you don't want to do it online, you can mail or hand deliver the homestead application to your county property appraiser office. The form is called the DR 501. It's a simple 2-page application. You can find it just by Googling Florida DR 501 homestead. It'll be the first thing that pops up. And that's this, and by that form is not different county to county. It's the same form for every county. All right, so this is what we mentioned on the previous slide. You have to include your driver's license, voter registration, and car registration, all with the updated address along with your application. And the deadline to apply is March 1st. Now, you can apply late, and I've found that assuming you don't wait till the absolute deadline to apply is September late. If you wait past September, you can't even apply late. What I find though, if you apply in most counties, let's say you miss it by a couple months, they're almost always accepted, assuming you meet all your driver's license, voter registration, car registration is all updated. Everything else with the application is fine. They'll still usually accept it. But again, the longer you wait, the less of a chance you, in theory, have. All right, this next slide is very important because I get calls on this a lot and it can be devastating. There are ways you can lose your homestead. First way is if you're claiming homestead or a similar residency-based exemption on another property, whether in Florida or in some other state. So, I say residency-based exemption because some states don't have exactly what we have in terms of homestead. It's a little bit different, but there's still exemptions based on the fact that you are actually living in that property in another state. So if you're receiving that in another state, you can't also that presupposes that you're living there, right? Otherwise, you wouldn't be getting that exemption. So you can't then also claim homestead here. If the property appraiser's office finds out about that, you lose your homestead. The next way is if you're renting your property for more than 30 days in 2 consecutive years. So it's a little weird because it's not a blanket prohibition on renting. In fact, you can rent your property for almost an entire year if you wanted to. The key is that you're not doing that for at least 30 days in 2 consecutive years. The third way is if you are residing primarily at another property. So the property appraiser has enough facts to see that you're not actually living there. Maybe you're not paying any utilities at this primary residence. Maybe you forwarded this is actually the way they find out the most. You forward your mail to another home, right? Why would you, it just doesn't make sense in general that you would do that unless you were actually living at that other home. So that's one way they find out very easily. And then the fourth way is if you're transferring the ownership of your property, so such as to an LLC. So when you lose your homestead, the obvious consequence is that you lose that 3% capped value because your assessed value then resets to market. It can get even worse though. And that's this last slide. Let's say you did something years ago that were grounds for losing your homestead, but the property appraiser doesn't find out about it until now. So they can not only take away your homestead, but they can back tax you in the amount of the homestead tax savings that you received. And so the furthest back they can go is 10 years. So if we're looking at 2024, maybe you did something in 2015 that were grounds to lose your homestead. They can go all the way back and tax all those years for in the amount of the tax savings, plus a 50% penalty of those tax savings and 15% interest every year. It's devastating. It is the worst thing that can happen in property tax for a homeowner by far. Because not only that, you get a tax lien recorded on your home. So if you don't pay the amount of the difference, that tax lien gets recorded. You are in a bad shape. It doesn't matter how you could be talking about a property valued at a couple $100,000. This will result in a big number, especially if it's something that happened years ago that they're now finding out about. So I hate to end this on a bad note. That is my last slide, but it's one of the things, it's the worst calls I get because it's devastating. And more often than not, there was a reason you lost the homestead. Maybe you were renting it out and you weren't supposed to, or you transferred ownership and the property appraiser's only just now finding out about it. So anyway, that concludes my presentation. Hate to end on a bad note, but it is arguably the thing you should remember the most about homestead.
Awesome. Thank you so much, Dan. I vote Dan Wolfe for adjunct professor at whenever you're ready to go there.
Oh man, I don't know if I'm ready for that.
Yeah. Well, folks, a few more minutes to think of any last minute questions you might have. I don't see anything in the chat or the Q&A yet. Some folks, it takes them a few minutes to process and then ask some questions. Someone did already through the chat say thank you for this useful training, and I couldn't agree more. Let me put in the CLE code while folks are still brainstorming. That CLE code is 2405515N as in Nancy. Again, don't worry, that'll come to you in the form of an email along with this recording if you don't have time to jot it down now. It does get you 1 general CLE credit and 1 real estate certification credit through the Florida Bar. So as I was providing that CLE code, Dan, something did come in through the chat. Somebody asked, is there any reason you would want to appeal a tax assessment to increase your assessment for profitability purposes?
Portability, yes, for portability.
Or portability, sorry.
No. That's absolutely 100%. If I had more time, I was debating whether to include more information, and that would have been something I would have gone into. So I actually appreciate that question. Yes, that is the only time that I can think. It is, I think, the only time where you would want to increase your taxes because, or, I'm sorry, increase your value. Because what homestead law does also allow you to do is if you already have homestead somewhere in Florida, you can then port or transfer up to $500,000 of that value to your new property, right? So, sometimes you have a very small differential. Maybe for whatever reason, you had Homestead, but maybe the market value is only, I like using $1 million because it's round numbers, but maybe the market value is at 1 million, your assessed value is only at 900,000. So in theory, you only have $100,000 to now port to your new property to reduce the value. But you're like, wait a minute, that's not fair. I know my property is worth more than $1 million. You can actually go in and using all the same evidence, whether it's an appraisal, whether it's comparable sales in your neighborhood, or in a lot of cases, maybe you're already under contract to sell your property for way more. You can show all of that to actually argue for an increase in the value so that you can now maybe you're successful in raising the market value from 1 million to 1.3. So now you have this difference of 400,000, right? Assuming $900,000 assessed value, you can now port $400,000 to reduction to your new homestead. So portability is huge, and that really should have been in my slide the more I think about it, because if you already have Homestead, you really want to take advantage of doing that if you intend on moving somewhere else.
Awesome. Very, very cool. So one more question came in. Do you have time?
Yep.
Awesome. Okay. So somebody asked, how often does the county check for the death of the homeowner? I've seen adult children living in a home and not notifying the county, but paying the discounted homestead exemption rates.
That's a good question. There is no answer to that. I hate to say it, it's almost luck of the draw sometimes. I've seen taxpayers get away with it for years. But when they find out, like let's say it's a situation, just to illustrate it, where a homeowner has homestead and they have kids there, and the kids are adult kids, so they can't fall under any exception to keep the homestead once the parent dies. When that parent dies, you lose the homestead, right? The kids don't inherit that homestead. So what can happen in that scenario where you might think, oh, maybe I can skate by and the property appraiser will never find out about it? More often than not, they will find out about it. It might just take some time. And when they do find out about it, that's a scenario where they can then go back and back tax and do the 50% penalty, 50% interest, tax, all that terrible stuff. The answer is how often. There's no good answer, and it really depends on county to county. Some counties, the smaller counties with less properties in general, seem to be more on top of it. They're able to manage it more. The bigger counties, Miami-Dade. Again, Miami-Dade is pretty good though. They invest a lot of time and effort into their homestead department, so they do crack down on it pretty well. But I guess in theory, some things may slip through the cracks more. My advice is when the person dies, you should notify the property appraiser, because at some point they're going to find out and then they're going to back tax you. It's going to be terrible.
Yeah, gosh. Well, I don't see any other questions in the chat. I can say, folks, if you do have any additional questions for Dan, feel free to reach out to me. I'll forward them to him. I think that this is a really expansive topic and there's a lot that can be explored. So thank you all for your good questions. And thank you, Dan, for this. Folks in the chat also said thank you. When I roped you into doing this, I said, we don't really have many people that come and talk to us about these topics. And thank you for doing it in such a really melding the substantive, the black letter law, the statutes with the practicality. I personally don't practice in this field, but listening to you, I feel equipped enough to say, okay, I can look at this, I can pick this up, I can piece it together. If I had to show up, I'd know I'd have a little bit of a roadmap of what to do. So that is really what I was hoping for, and you knocked it out of the park.
Perfect. Well, I'm
Yeah.
glad to hear it. That was the goal.
All right. Well, it's 1:04. I'm sure you've got some things to do, and I know our audience has to also get back to work. But I can't believe it's Monday. Enjoy the rest of your Monday. And Dan, thank you so much for all that you do and for giving us a little time here today at the Statewide Training Initiative.
My pleasure. Thank you for the opportunity.
All right, everybody. Have a great rest of your day.